Greetings, everyone. My name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group. NPZ is Nachman Fulwani Zimochek Law Group. And we are immigration and nationality lawyers with a main office, our corporate office located in Ridgewood, New Jersey. And we also have a satellite office that is located in Raritan, New Jersey. And we also have an office in New York and affiliated offices in Canada and also in India. And we have the rare opportunity to be able to share with you some some tips about how to do consular processing today. And what I'd like to do is let my law partner, Ludka Zimochek, introduce herself, and then we'll launch right into some hopefully valuable information for you. Ludka?
Hello, everyone. My name is Ludka Zimochek, and as David mentioned, we are immigration attorneys, and we are here to answer some of the most important questions that we are getting from students on a daily basis.
So, Ludka, we've been in a very changing landscape, of course, in the in the consular processing area, and for me, I would say probably every other phone call that I've been receiving has to do with some nuance in the what used to be very straightforward. I mean, when a student would call and ask me how to do consular processing, I would, give them what I consider to be the skeleton, if you will, analysis of a consular processing procedure, which I'm just going to lay it out for you. I'd always say, well, there are two things you need to explain to a consular officer. One is, why are you coming and what are you doing? And that's going to be pretty straightforward because you're going to have an I-20 and you're hopefully you'll have a SEVIS record that sort of explains where you're going and what you're doing and what your program's about. And that's a relatively straightforward analysis. And then the second layer of analysis, if you will, has to do with Section 214B of the Immigration and Nationality Act, and that is what's called non-immigrant intent. And so, we prep our students and individuals who are going for non-immigrant visas at U.S. consulates abroad about what they need to show or what they need to say in order to demonstrate non-immigrant intent to overcome a potential 214B challenge to a visa application. So that was then. This is now. Now we're in a new world. We're in a world of can you do third country processing? We're in a world of how do you do an NIE?
And can you even get interview? Don't forget.
That's right, that's right. And can you even get an interview nowadays?
Yeah.
So, Ludka and I were discussing amongst ourselves, some of the top issues that are confronting students in the realm of this consular processing landscape. So, Ludka, maybe we can lay them out and hopefully do a drill down analysis for the folks who are watching this program.
Yeah, we prepared some questions that we get on daily basis, and I think it's going to be very helpful to the applicants that are applying for visa right now because school is going to start soon. So one of the first questions, David, is it important to have a lot of supporting documents when the individual goes to the interview?
Ludka, it's a great question. And there are various schools of thought on that particular issue. But I generally find that having, and just to give everyone sort of a basis for where these, where this advice or information is coming from, we have traveled throughout India, visited the U.S. consulate offices there, and this is information that we've received directly from the consular officers. And this was pre-COVID when we could actually travel to the consulates. So things may have changed a little bit, obviously, because of COVID. But generally speaking, I think that having discussed this with many of our colleagues being on various listservs, I'm not including information in chat rooms because we tend to find that information is maybe a limited in value. But the answer there is it's best to bring your documents with you. It's always good to be prepared. Take the documents with you, but we tend to find that the officers are not really that interested in reviewing the information or documentation that you bring with you. Okay,
Agreed. I
right,
absolutely agree. It's more important what the individual will say than
exactly.
the documents itself. It doesn't have as much weight as someone would think, especially in a high fraud consulates.
Exactly. And there's, I think, a psychological aspect to the applicants having the documentation with them, because as Lutka said, what you say, the officers at the US consulate have explained to us that they're all about articulation. They're all about the individual standing at the window and being able to articulate clearly what it is that they're coming to do. And again, articulating their non-immigrant intent. So that's what the officers are looking for. But I think that, again, psychologically, it's better to have all the documents in your hand, because if you have to allude to a particular piece of information in those documents, it's always better to have them with you.
That leads me to a next question that was not actually planned, but I just thought about it. How long is the interview?
Oh, that's a great question. And so it's important, I think, for anyone who's on this webinar to understand that the consulate officers have capitation requirements. That is that they have to get through a certain number of applications on a daily basis. And for those high volume consulate offices, such as those in India and throughout the world, they actually have to get through thousands. And especially now, in this particular landscape, given COVID, a lot of them are not, they're not fully staffed. So they have very high volumes that they have to deal with, and they're doing so without full staff. So, the interviews generally are very quick. I would say even 2 to 3 minutes is what you can expect, and maybe 2 to 3 minutes might even be, a very, that might be a long interview.
So now you can see how important it is that you're prepared, because within those 2-3 minutes, you need to be able to explain why you're going to study whatever you're going to study, and just answer the questions properly. So you could have that many documents. I think it's not as important as being able to explain what the officer is asking.
We generally find that what the officers don't want you to do is to shove a big pile of papers into under the window. That's not what they're about. They want you to stand there and to give what I refer to as the elevator pitch. So what you want to do is you want to be able to explain in the amount of time that it would take the elevator to get from the first floor to the third floor, exactly what you're doing there, what you're going to be doing in the United States, and why you're going to be returning either to your home country or to someplace outside the United States following your temporary stay.
Next question. Is the interview in English, or is it in the home language, whatever the language is in that country?
That's a great question, Lutka, and it's one that I frequently get. And the answer is that for students generally, they have to do their interviews in English. However, they are allowed to ask for the.
Why is it in English?
Well, it makes sense if they're going to be studying in an English program, that's the reason why they're going to have to do their interview in English. I think that the officer is using a common sense approach. This is a totality of the circumstances analysis for the consulate officers to determine whether or not the individual should be coming to the United States to be in an English language program. In a program, I guess, that's going to be taught in the English language. If they're coming for a foreign language program, then it's a different story. Then maybe a consular officer may start the questioning in English, and then maybe turn it over to someone who can continue the questioning about the reason why the individual is coming, but do it in their home language. So that's
I
that's usually
actually
the way.
seen denials, for someone coming for a master's degree, not being able to speak English that well because they were questioning how you're going to study. So good point.
Exactly.
Next, what do you do, or what advice do you have for students that get 214B denial? It's the most common catch-all kind of denial, what is your advice or how to deal with it? What should the student do?
It's a great question, Luca. And so if a matter is denied, the officer will hand the student a piece of paper, and usually it's a what we call a 214B denial. And the student may say, "Why is my case being denied?" And the officer will just say, "Oh, well, it's on this piece of paper," and it has to do with what's called non-immigrant intent. We talked about it before. And what it is it's the what the officer is saying is that they don't feel that the individual is going to return back to their home country or to a place outside the United States following their temporary stay. However, what we have found, Ludga and I have found that 214B denials are actually issued for any purpose. I mean, it's almost like they use 214B as a catch-all. So I think that your next question was, what can you do? Well, there are a couple of different things that you can do. I mean, one is, you can definitely reach out for a immigration professional like ourselves. But there are, of course, are other people who do this type of work, and to try to figure out what the reason why the case was that was denied. And then once that analysis is complete, maybe reformulate your strategy, maybe go with different circumstances, maybe different timing. So that's one possibility.
So can you reapply? Can you reapply
You
for
can you
the
can
same visa?
absolutely you can always reapply. The U.S. federal government is always interested in your application fees. They will never turn them away. But if you're going to go back in, again, go back in with an argument or explanation about changed circumstances, and give the officer a reason initially, right when you're about to present your case. Just make sure you make it perfectly clear to the officer what the changed circumstances are that bring you back in front of the officer. And that brings me to a point which I think you might ask me about, Ludga, and that is, can the officers see prior denials
Yeah.
in their database? And the answer is that they can. They actually have access to prior determinations that are made at the consulate through a process called PIMS. So they have access to that. And if they see a prior denial, that might already in their mind, set the tone for the next interview. So
It
again, that's
shouldn't,
why
but it
it
does. It shouldn't. There
exactly.
should be no prejudice, but of course it does. I have a question for you. Actually, I got this question yesterday from a client. How about what if I decide to go to a different embassy? Will the officer see that denial if I decide to go to a different embassy that may be better?
That's a great question. So that actually kind of takes me down two different roads. The first road is, yes, they can see the denial at another consulate because that's PIMS. PIMS actually sends out the approval, or places information into the consulate records. So they actually have access through all consulates throughout the world. But then the next thing is, at some point, it seems to me that one of those consulates may have been third country processing, possibly. In India, you can go to a different consulate. Mission India allows you to go to any consulate where you can get an interview. So we oftentimes, will tell our clients to go online and just check all of the consulates to make sure that, to see whether they can get an interview, which that's really important because obviously timing is important there. But then let's say you're doing third country processing, we'll I guess come to that question. But if you're doing third country processing, is that okay to do third country processing? So Lutka, I'm going to put that back to you.
Yeah.
Tell us why you would or would not advise someone to do third country processing. So let's say, and I got this question the day before yesterday, and that is, I had a client who wanted to get her F-1 in Barbados, even though she's from India. So would you advise that that's something that should be done, or what do you think?
So it depends. In my client situation that visa was just denied, I wouldn't recommend it because it may seem as a forum shopping, which means that, you're trying to get better embassy. As you mentioned right now, it's difficult to get an appointment. So if the reason is that you cannot get appointment anywhere else, or you have a good reason to be in that country, then maybe yes, it's a good idea, especially now in this pandemic. But on the flip side, we get a lot of questions about Canada, for example. Um, I'm not a fan. That's just my personal opinion, because you could be stuck there. What if the visa is refused under Section 221G, and then a person will be there for weeks or months? You never know. So it's a big risk going to the third country. And also, I don't think those consulates are too thrilled to have nationals from different countries, especially now with limited number of appointments. So preferably stay in your home country. But there are circumstances, that I guess it would work where you go to the third country. But I think it needs to be evaluated. What are the pros and cons?
I think that's a great point. And, what we've noticed, Ludga and I have actually found over the last 6 months that some consulates have opened up to third country processing. And because so many people are trying to do third country processing, they've immediately closed up. So one, for example, was Mexico City. They announced that they were taking third country nationals for visa stamps. And then I think it was just a week later that they closed. And then the same thing happened in Vancouver. So they opened and then immediately closed. So this is the landscape that we're dealing with right now. But I am reading on professional listservs among, discussions among our colleagues, that there are folks who are getting visas in third countries. So for example, there was a Brazilian foreign national who actually went to Ecuador, got an appointment, and was able to process the visa in Ecuador. So that's third country processing. The problem with third country processing, just so that everyone is clear, is that the officer doesn't have the intelligence on the ground about you, and because it's not your home country. So if an officer has like a question in their mind about the process and whether or not you qualify, then that thought that they might have in their mind could lead to a denial. And so, or as Ludka properly points out, an administrative hold. And then if it's an administrative hold, that could take weeks, it could take months, it could take years to resolve. And then the question becomes, will the visa that you have that allows you to be in that foreign country run out while you're waiting for, the visa that you've applied for? So for example, going to Canada, you need a Canadian visitor visa to get to Canada to be able to process at the US consulate there. And then meantime, if you end up in a 221G hold, and that hold takes you beyond the period of time that visitor visa is good, then you're stuck. You have to come back or do something. So third country processing is an additional layer of analysis, which really requires detailed strategic planning with an immigration professional, for sure.
One point about the prior denial or refusal under Section 214B. So if you're applying and you're doing the new DS-160, there is a question about it. So you have to fill it out truthfully, and you have to mention that, yes, it was denied. And there is also a box that says explain. So while the officer will see it in the system, it is very important that you do list all prior refusals or denials, so there is no misrepresentation or fraud in the future. So,
and what if there is a misrepresentation or a fraud in the future?
we are just
I know you are.
We are going to that point. And I'm gonna actually just hold on it, but I'm gonna ask you exactly either fraud or what if the individual has prior criminal issue. So both of these, fraud or a criminal issue, will lead us to one thing.
Right. And what are the most common ones that we see among our students? I think that one is probably charges for weed. One would
DUI.
be DUI. What else? What about traffic violations? Are those important? Probably not, although they are asking for the driver's transcript to ensure that the violation was not a DUI, right? So if you have tickets, probably not a bad idea to travel with your driver's abstract. If you've been to the United States and you had tickets, right?
But any prior criminal issue, it's important just to go over it and see the disposition letter, because oftentimes we see, oh, it was dismissed, it's nothing, or even better, the lawyer told me that it's expunged. It doesn't matter for immigration, it does matter. So it's very important to review it. I think you really need to seek professional help of an attorney to go over it, because it could make you inadmissible, the same as fraud. Maybe 5 years ago, you applied for visitor visa and you were so upset that you just left the embassy, but you got a fraud determination. So this is all very important because it never goes away. So let's say that you have criminal issue, or you have a fraud issue. What is the procedure, David, that the student or applicant can do?
So there are waivers that are available in connection with the applications that are made. There are two non-immigrant waivers that immediately come to my mind, depending upon what the basis is for the inadmissibility. There's a 212 D3 waiver that's available, and there's also a 212H waiver that's available. And those are made in connection with the non-immigrant visa applications. And the way you're going to know whether you're inadmissible, Ludia, and just they're going to get a white piece of paper that's going to say you are inadmissible based upon 212, and then it'll give the subsection. So the idea would be to get that immediately into the hands of a immigration law professional who can take a look at it and let you know what the basis for inadmissibility is, and then whether or not a waiver is or is not available for that charge or for that claim that the government is making.
So of course, we're not going to discuss the waiver, but that's something, that's going to take very long time. So it requires a lot of planning. This is not going to be resolved in one day. So, but, if you have any prior immigration issue, any prior criminal issue, and you're concerned, it's much better just to have an attorney review it and go over it before you even apply you do DS 160.
So Ludka, the second part of the analysis that we discussed before about, obviously, the students should be well armed with the reason why they're coming. They're coming for a full-time course of study at a particular academic institution in the United States. So that's relatively straightforward, and they're going to have a SEVIS record, which is going to demonstrate that, and they're going to have Form I-20. So that's all going to be pretty clear and easy to prepare for. But let's talk a little bit about non-immigrant intent, because I think it's really important for the students to understand what kind of information and documentation should be discussed at the counter about their non-immigrant intent. What sort of evidence do we tell the students to discuss about their non-immigrant intent?
So for example, it just depends in what, I'm going to give you an example of my yesterday's client. I like to use that. So he is a business professional, for example, who was applying for F-1 students. So, he brought documents regarding his business, that he's leaving his spouse and his kids.
Okay. Family members behind. Yeah.
So I think that's really strong indication that he will return back after his studies. And I think he applied for MBA. So,
okay.
This was your perfect case. It's much more difficult with younger students that don't have, too many ties.
Right. Well, let's say they have a bank account. A bank account at home would be helpful, right? What if they have?
If they own apartment or
own a car, own a lease, own a motorcycle, maybe. So what basically what it is that, your lives better than we do. So you sort of are well armed to be able to understand what evidence to present to the consulate. But basically what they're looking for is ownership of property, because the thought process that the officer has is that individuals who are coming temporarily to the United States are going to return to the place where they have their property. And so whatever property that you have will be obviously good evidence. What about ties to a religious community? Maybe someone is a member of a Hindu temple, a mosque, a temple for many years. So maybe they can articulate the fact that they've been members of a religious community. How about social community? Maybe an individual is a member of the Boy Scouts, a member of some type of organization that does charity work. some type of organization that may do some other social work or something.
It's
So those, yeah, go ahead. I'm
those
sorry.
are good ones. The more problematic is if if the applicant has family in the United States. That's a little
Exactly. Yeah,
tricky. So you need to explain that as well, because actually on the application there is a question: who is in the United States? So that's going to be definitely red flag if you have mom or dad in the United States who are U.S. citizens or green card holders, or if you have a brother or sister. So that, I think needs to be stated on the application. That's number one. You don't want to lie. And that could make it a little bit more difficult. So again, it's just, you need to explain why
exactly.
you're going to be returning back to your home country.
Exactly. And when I speak to students and coach them, which I think that sort of is the way we're going to end up coming to that point, is that coaching is a really valuable service that can be provided to the students, to anyone who's going to the U.S. consulate offices abroad, to be able to prepare that elevator pitch and to understand exactly what they need to say and how they need to say it. In fact, I tell students, stand in front of the mirror and just make a presentation, a quick presentation, so that you know that you can cover all of the information, all of the material as quickly as possible and as articulately as possible in order to get a favorable determination from the consulate.
So that brings me to our last question, David, and I think we've touched upon it, but I think it's super important. We've met in the past, before pandemic, we've met with many consular officers. What was the most important thing that they told us regarding the interview? What's the most important for the interview for the applicants?
Well, I think we touched on it, is
You
the
did.
non-immigrant. Yeah, I think it's the non-immigrant intent and the ability to clearly and concisely articulate the reason why you're coming to the United States, and that it's a temporary visit. Those are, I think, the most important. Those are the most important.
So
Now, the other
not
thing,
documents, but just to be able to explain in 2-3 minutes, tops 5 minutes. So that's what the consular officers always mention, that that's the most important, that they could have a lot of documents, but if they cannot explain properly why they're coming, that's it. They're going to make their mind and that's it.
exactly,
Remember, it's
and
a discretionary decision. So, it's very, very discretionary.
exactly, and so I just want to go back to the administrative hold, the 221G processing, because if your case ends up as a 221G, it's not always clear as to why it's been, it's in a hold. So I think that that's also something that we or any other immigration professional can assist you with, is to try to find out why a case might be in an administrative hold. Sometimes because we have experience with administrative holds at various consulates throughout the world, we may be able to figure it out from the documents and information that you might have available. Sometimes it requires us to initiate a communication directly with the consulate. Sometimes it just takes a gentle nudge, which many of our cases actually have, where a gentle nudge to the consular officer and to bring that case to the top of the pile might be enough to move it along. So, so if you find yourself in a position where a 221G hold is issued, don't, throw up your hands and say, oh, it's a refusal and, it will never get a result. That's the time to reach out either for your international student officer or your designated student officer, who can be of tremendous assistance because they also have a line into the U.S. consulate offices abroad, or to an immigration law professional who can assist you to, again, give possibly the case a gentle nudge.
So if you have any questions, feel free to contact us. We are very accessible over the email, phone, and good luck with your interview.
Happy to assist. Thank you so much. Excellent information, Ludka.